Hello, everyone. My name is Anthony Velasquez. I'm the Chief Product Officer here at PharmaForce. We are a solutions provider for 340B and PBM services in the pharmacy healthcare space. We work with covered entities all across the country. If you attend these webinars regularly, thank you so much. I really appreciate. I spoke to many of you at the conference in San Diego just a few weeks ago, and was so encouraged by your feedback and encouragement to continue doing these. So I really, really appreciate that. If you're here for the first time, a double welcome to you. I hope that you find a lot of this information that you're going to learn today valuable and valuable information that you can take and implement in your 340B program. So again, thank you so much for joining. Really, really excited to go deep into this topic as we do every month on a different topic. Today, we are talking about a little known process in the 340B space. The reason why I say it's not well known is because I have been in the 340B space working for grantees and hospitals across the country, going on close to 14 years now. And I had not fully really understood the administrative dispute resolution process. I understood the concept, and as I learned more and started talking to other folks about it, really, really interesting stuff that I'm excited to share with you all about what is going on with this process. So that's what we're going to unpack today, as the title of the webinar is unpacking the administrative dispute resolution, or short ADR process, and talk about how it is a key component of compliance for covered entities to have a way to let their claims be heard when they are not able to access 340B pricing. Let me start off by saying, let me kick this off by saying the administrative dispute process is a very rarely used mechanism. Okay, you'll see more as we unpack it, more, but it's very rarely used. It is not something that every covered entity is doing. From conversations that I've had with other legal experts in the field, there is probably under 10 recently that have gone through this process for many reasons. So, and I'll share some of that. So, let's go ahead and kick it off. Let me go ahead and share and go to the next slide here. So, full disclosure before I go into a lot of this, especially with this process, because this is a very complicated, very technical process in the 340B program. But the information that I'm going to share is, including any analysis or opinions, represent my personal views as a presenter. So I'm going to share information with you that I ask that you please confirm with your counsel, your compliance team, related to how your covered entity decides to use that information. These views do not necessarily align with the official stance of PharmaForce or its affiliates. This content is intended for informational purposes only and should not be considered legal, financial, or professional advice. Neither the presenter nor PharmaForce provides legal representation. Viewers should seek guidance from their own legal advisors before making any decisions based on this information. So I have to get that out there. You all know the world that we live in these days. So I just have to get that out there at the beginning. So as you can see, I'm not in my normal home podcast office with my mic and my lights and all of that. I'm on the road this week, traveling with my family and doing this webinar. And yes, feel bad for me because my wife is not happy that I didn't plan this accordingly. So so you're welcome to feel bad for me. But anyways, let's get to business. So what are we going to talk about today? So first, we're going to talk about the administrative dispute process and what is it. We're going to talk about the why it matters, talk a little about the ceiling price and the overcharging. We're going to look at the workflow if you meet the criteria of being at the level of submitting a claim to the OPA, the Office of Pharmacy Affairs, how you can do that, and some tips on a compliance checklist that you can have. Let me also say that the reason why this is a very important process to know is because this is a process that's being explored to help covered entities resolve instances of not being able to access 340B pricing as a result of a lot of the manufacturer restrictions. So we are entering a interesting part of this manufacturer restriction process where we have 20 plus contract pharmacy access bills at a state level. So now, when those bills are passed and the manufacturer restores pricing on your 340B catalogs, we have yet to see at a wide scale how quickly that can be done and if entities get the pricing restored in a timely manner, and what to do about the reprocessing of those claims when no 340B pricing was available. So there's a lot there's a lot where there's a lot of chatter in the industry of the using this process to help resolve some of the differences between covered entities and manufacturers as it relates to pricing. So that's sort of the context why I think this is a timely thing to discuss because of the potential of 20 plus states passing contract pharmacy access bills at a state level, manufacturers then restoring the pricing on that, and then the fight that entities are going to have back and forth about getting that pricing restored and all of that. So here's an overview. Um, the administrative dispute resolution process has gone through a very long history of iterations and, went a period of darkness where nothing really happened from HRSA and the OPA, a period there was a mandate that there needed to be a binding agreement on this. And I'll share a timeline for you on that. But at its basic, the basic way to explain it is last year, April of last year, HRSA issued a final ruling on the administrative dispute resolution. Now, this is kind of like a final ruling because there was another one prior to this, and I'll share the differences about this process. It's a formal mechanism to resolve disputes between covered entities and manufacturers participating in the 340B program. So think about it like, in this world of manufacturers are, suing states, suing the government, lawsuits all over the place. There have been instances in the history of the 340B program where entities and manufacturers disagreed on a pricing, particularly a pricing situation, and have not been able to resolve that in a good faith effort, and then need a third party to step in. So the goal of the administrative dispute resolution is for HRSA and the Office of Pharmacy Affairs to step in and be that party that receives claims from covered entities or even claims from manufacturers. For the sake of this presentation, we're only going to talk of the context of a covered entity. So if a covered entity has a claim that, hey, I'm not being provided the 340B ceiling price per the statute, or I'm being overcharged, or I overpaid, and that's not resolved, the ADR process is an avenue for the covered entity to present that claim to the Office of Pharmacy Affairs, and they will help resolve it. So essentially, it's a process to help entities ensure that they're able to procure drugs at the ceiling price. So that's the basics of it. Okay, that's what it is. It's a hey, I've exhausted all my efforts working with the manufacturer, trying to restore pricing or asking why I'm not receiving the ceiling price, and it's not going anywhere. So this is, a solution for covered entities to follow. Again, I have been in 340B for going on 14 years now. I have never spoke to a covered entity that had actually gone through this process. To be fair, it is a process that has been more defined, I would say, in the last 4 years. And the new rule is it's only under a year old. So if you are on this call and you're a covered entity that has a situation where you are struggling to get pricing, being significantly overcharged for a product, working with the manufacturer or ESP, and are not seeing a solution in place or being able to overcome that challenge, this could be an available process for you, right? This is not to be taken lightly. This is not for everybody to do. This is not for you to go out there and as a covered entity to submit these claims, to HRSA, because there are some requirements before you submit a claim that I'll go over. But this is, I think, a step in the right direction. Let me walk you through a brief history. So we all know the program was started in 1992. In 1996, an informal dispute resolution guideline was published by HRSA. And basically, it was to help resolve disputes between covered entities and manufacturers. That is not new. Disputes between covered entities and manufacturers are not new in this program. I think it comes with the fact that this program is complicated and there's many aspects of the program. But again, these guidelines were a good faith effort to resolve issues without formal intervention, without HRSA needing to come in or the Office of Pharmacy Affairs needing to intervene on every single individual issue. In 2010, the Affordable Care Act added language. It was called Section D of 340B Section D that then created require for a HRSA and the Office of Pharmacy Affairs to implement a binding ADR process to resolve disputes of overcharging, diversions, and duplicate discounts. Right. So if you're a covered entity, you're overcharged, you will now, have an avenue to submit that claim. HRSA starts, doing extensive audits in 2012, but nothing really was finalized about this rule. A couple of administrations came and went, and a formal administrative dispute resolution process was never put into place. It was never active. Um, HHS issued a final rule December of 2020, establishing the initial ADR process. And then then there was an implementation that faced some challenges. So basically, what was happening is that the process was becoming very intensive. It had a minimum threshold. It was very, very long to resolve anything. You needed to get counsel and lawyers and things involved. So it just became very, very cumbersome. So HHS issues a notice that it will revise its ADR process, aiming to make it more accessible and less formal, especially for very small covered entities that might have a claim to bring before the Office of Pharmacy Affairs that does not, meet the threshold, and then the final resolution, the final ADR language in the Federal Register was released in April of 2024. Okay. Um, no one that to my knowledge, and from the information I was able to gather, again, it's very rarely used, and we don't have entities submitting claims for this. I have heard of some efforts to submit claims of overcharging as it relates to the manufacturer restrictions that have happened, and I've heard of some groups that are getting together to submit claims and kind of to through the ADR process with documentation and things like that. But we haven't. It really has not been tested from everything that I could gather. So that's sort of some of the background history about that. The the differences between the 2021 ADR rule and the 2024 ADR rule, which is the one that was passed just last year, or the one that was finalized last year, it's a better way of putting it, was one, formality. So entities were afraid to use the process because it was similar to it just required adhering to a lot of rules. You really couldn't, like a 340B, compliance team couldn't really do it. You needed to get a lawyer involved and things like that. So the 2024 one hopefully makes that a less formal, more accessible process for covered entities of all sizes, even the ones that are not able to, get a lawyer to sort of help them guide them through this entire process. Number two was a minimum threshold for claims. So basically, in the 2021 rule, your claim before it was brought to the Office of Pharmacy Affairs had a minimum threshold of $25,000 of damages. So when you were submitting the claim to go through the administrative dispute resolution, it needed to have, overcharging, for example, of greater than $25,000. Okay. The new rule does not have a minimum threshold and allows claims of any size, of any size. The panel composition changed a little bit. So previously there were members of HRSA, CMS, and other government organizations under HHS. The new rule is subject matter experts from HRSA's Office of Pharmacy Affairs. The old rule had no explicit requirement for a good faith effort. So good faith effort is you're resolving that with the manufacturer. The new rule does, you do have to demonstrate that there was good faith efforts in, in before filing the claim. And then lastly, there's a process for reconsideration. So previously there was no formal process, so you couldn't say, "Hey, no, I really think my claim needs to be reconsidered." And now that is possible with this new rule. So hopefully that makes sense. That clears up a lot of the differences and why the new rule matters. So why does this even matter? Why are you here as a covered entity? Why do you even care about this? And that's for a couple of reasons. Number one is this is a really key process for covered entities that are in disputes with manufacturers. Now, listen, I have done this for a very long time. I'm not naive to know that finding even having a process to find overcharges is very difficult. And sometimes entities don't have the resources to have someone go through invoices and find instances of overcharging, and that with the manufacturer restrictions, there have been instances where entities have paid the full price on their drug catalogs, because of different situations. So, I this is one of those things where I think it's happening, and it just requires a significant amount of effort and resources for an entity to do in order to find these instances of, overpayments, overcharges, and things like that. So additionally, it helps to prevent overcharges that you are paying the 340B ceiling price per the law. Um, Helps to solve disputes between entities and manufacturers for access issues. If that was something that was, you're not being offered a particular product under the 340B program that's a participating product. It ensures adherence to the 340B guidelines for all parties. I have not heard even the manufacturers really using this ADR process. So I think even the manufacturers don't really utilize this. But I think for covered entities, I think it's important to know that there is a process in place to bring these claims and these disputes in order to ultimately have fairness and transparency, and to have a voice without having to go through a full legal process, that requires expensive, right? We're talking about covered entities and some are covered entities in rural areas, some are covered entities that are grantees, and even some are hospitals that are in the face of, massive losses of insurance reimbursements and increased cost of staff, and having to, have this process where you have to spend a lot of legal fees to make a claim is a good thing, I think, for the program. So, um, as you all know, the 340B law and regulation requires the manufacturers to offer a ceiling price and not overcharge. So, I'm not going to bore you with all the details of that, but the essential calculation is the average manufacturer price minus the rebate amount becomes the ceiling price, and that is the ceiling price that has to be offered by manufacturers to the covered entities that are eligible for 340B pricing at their hospital locations, contract pharmacies, et cetera, in the program. So that's what we know. So now let's talk about what are instances where a covered entity is going to have issue with pricing or access. So what are some examples that could begin the process of considering an ADR, the Administrative Dispute Resolution? Number one, if you're not getting pricing on an NDC, so let's just say you are reviewing a drug catalog at a particular pharmacy, at your infusion center, at your hospital, and you're not getting 340B pricing on a particular drug, and that manufacturer is available in the OPA database and participating, and you reach out to the manufacturer and try to, understand why, and there is no resolution to that. That could be something that you can consider for an ADR process. another big thing, and probably this is the thing that I hear the most that entities are struggling with, and that is loss of pricing from ESP submission data. This is a huge headache for covered entities these days. Covered entities that are in states and working with manufacturers that require submitting of ESP data. There are claims that not every single claim is considered as a conforming claim or being approved in the ESP system. There are instances where there are, claims where they're going back and changing the status. I heard of something like that from a covered entity of something, and then considering, the accumulator balance being, in danger of losing pricing. There are entities who are struggling for weeks, just going back and forth trying to get pricing restored. And then that time that they lose the pricing, they struggle with getting the reprocessing of the claims, to catch up on those accumulations. So a lot of the pricing things that I'm hearing from entities on a day-to-day basis are related to the ESP process. I would say previously some of that has gotten better. Previously, there were instances where the next one will happen, point number three here, where there will be errors and wholesaler contract loads from what I hear on a day-to-day basis. That has gotten better. That has I've been in managing 340B programs where a 340B pricing is not loaded. It's pretty easy to solve. It's not anything that would, require even communicating with the manufacturer, but it is something that if not monitored, that could be the source of the issue. Not that the manufacturer is not offering pricing, but that you don't have the PHS pricing loaded on your 340B account. Instances, I've heard this on a rare occasion, instances of refusing to provide 340B accounts because of the way things are registered on the database, and also ceiling price calculation errors. And those you would see where the manufacturer will come out and say, hey, we overcharge. We're voluntarily offering to provide discounts to entities. So these are all different. There's probably others that I didn't document here. This wasn't intended to be, a sort of a catch-all, but these are all different instances where you could be facing pricing issues. And I'm going to get to the end, because at the end I want to share a checklist, a compliance checklist that has a compliance process that you can follow to find instances where you are being overcharged. Okay. So let me back up a second. Let's say that you find an instance where you were overcharged, you were not provided the ceiling price, you attempted to, follow the process and reach out to the manufacturer or to the wholesaler and have not been successful. And you get to that point. So you have a claim, you have damages, so you overpaid or was overcharged on a particular product. You made the good faith attempt to resolve that outside of this process, and that failed. Then you can file a claim, and that claim will go through a process that looks like this. So you file a claim. The claim then is evaluated by the Office of Pharmacy Affairs to see if it meets the necessary requirements. At a minimum, and you need to have documented a good faith effort to try to resolve the claim and provide the right documentation and all of that. A panel is designated to handle the case. The panel reviews and analyzes, and then the agency issues a ruling, and then either party can disagree, and if they disagree, it goes to the OPA director. And then the Office of Pharmacy Affairs then provides a corrective action plan for the party that is found at fault. Okay. So that's kind of a simple flow of how this process will work. So really interesting stuff. This was again, I don't know entities that are really doing this or have done this. I haven't spoke to anyone. I'd be curious to know if any of you that are on this call have followed this process or have filed a claim, and has it been, and will be willing to share what that was like. That would be really interesting. If you have, I would love to hear from you if you have done that, because I have not been able to find someone who has done that, and has done it successfully, or even if it wasn't successful. All right, now let's talk about the ongoing compliance checklist, because this is where I think is, um, if you're sitting on this webinar and you're thinking, I don't even know if this really applies to me. I don't even know if, this really matters. My answer to you is it does, and you probably don't have a process in place for looking at your invoices to see if you were charged the ceiling price. And that's why I think this doesn't really, you think this may not apply. Because when I first was, putting this topic together in the content, I was thinking, I was like, I don't know that any entities really care about this process because it is so rarely used. I do think, by the way, I do think entities are scared to engage the Office of Pharmacy Affairs, on something like this too. I just don't think that that's something that any entity is ready to just say, hey, I'm gonna, you know, start opening a claim with the Office of Pharmacy Affairs, and it's gonna have to go through their compliance team and legal. So it has to be a very big claim, I think. And I say that just having worked in big hospitals, for example, and grantees and small health centers, that that is the last thing that you want to do. It's very time consuming, it's expensive, you need a lot of people, requires a lot of effort. Um, so the one thing that I would say is if you don't have a process in place to audit at least a sample size of invoices, I highly, highly encourage you to do that. So especially now where we have a lot of manufacturer restriction issues, and blocks and pricing remove and pricing restored and things like that. Um, there have been some wholesalers that are working on completely removing NDCs that don't have a 340B pricing from the catalog so that it's not even able to be ordered. But some of that's a hit or miss in some cases. But let me just say this. Number one, I think that this is something that you should have a policy and procedures for. So you should update your policy and procedures if you don't have it to incorporate, an ADR process if that and what your personal threshold will be. So this is similar to if you have a self-disclosure, process, for example, if you have that documented, I think this is similar of, okay, what is your entity? Again, this is not required. This is a recommendation. But what is your entity's threshold of overcharge damages to consider an ADR claim potentially? If that's something that you're in, every entity is different. You might have this down pat. You might be auditing every single NDC, and that's great. Um, and that you're reviewing. Point number two here is that you're reviewing a sample size of purchases and invoices to detect pricing discrepancies. That's really key. I don't think that has been really solved in the industry. And it's a very, it's a difficult thing to solve for sure. There are some companies out there that I've heard that are, have ways of tracking this and all of that. But yeah, it's a tricky process to solve for sure. Because the ceiling price is primarily tied to the database in the Office of Pharmacy Affairs, and the authorizing official and the primary contact are the ones that have access to that. So, but it's not impossible. There's still ways to do that. So here's a quick monthly step by step that I'm recommending that you, as a covered entity that are on this call, follow in order to ensure that you are able to at least catch pricing discrepancies. I think 99% of the time you will be able to resolve this by going to the wholesaler, and not even get to the point that it gets this far, but the process exists if you do. So number one, number one thing for your checklist is, on a monthly basis, pull your top 25 NDCs by 340B spend from all your 340B accounts. Okay. You could do this across the board. You can do this by account, but similar to doing a claims audit, pull your top 25 NDCs by drug spend. Once you pull each of those purchases in the last month, for example, and you pull each of those NDCs, you're now going to pull in the ceiling price from the OPA database. Okay. If you're not the authorizing official or the primary contact, you might not have access to that. That is, might not, you're not going to have access to that module within the OPA database. So you have to work with your team to get access to that. But those are the two, unless things have changed, but those are the two um, points of contact at a covered entity that can access the 340B sealing file that's behind the credentials of the Office of Pharmacy Affairs for covered entities. Now you have your top 25. Let's say you spent $100,000 or $1 million on a product in a month that was 340B eligible. The price per package you paid, let's say it's $5,000. The ceiling price is $1,000. So you overpaid by $4,000. You're going to find that from the ceiling price data. Okay. So you're going to check each of those purchases for the correct ceiling price. You're going to use a ceiling price file for that. You're going to pull you can even pull your actual invoices from the wholesaler as well to double check in case you're pulling the data from a TPA or some other source. And if you identify an overcharge, your first layer, the first person you want to reach out to is your wholesaler representative. That's where you first want to start. You identify, you quantify the overcharge, you reach out to your wholesaler representative to help further look into and resolve the instance of overcharge, and hopefully is simple and it's a simple credit, and that credit is then added to your account and all good. You don't have to worry about anything else, right? And I think that will be 99% of the instances. Okay. If reaching out to your wholesaler doesn't work, doesn't get you anywhere, sometimes they themselves reach out to the manufacturer and involve the manufacturer. If not, you as the covered entity representative can reach out to the manufacturer to request or point out that you were overcharged for a certain time period. And sometimes that gets resolved that way. Okay. If in that good faith attempt to resolve that is not resolved, or for some reason you are ignored, the pricing, they dispute the pricing that you're presenting based on the ceiling price, which I doubt that happens. But if it does, and you document that, then you may consider following the administrative dispute resolution process. Okay. So this is not something you're going to do monthly for the ADR, for example, but the step-by-step of auditing your top 25 NDCs. I know if you are a hospital with a large contract pharmacy network, like that could sound daunting and a lot of work. But maybe pick a few of your busiest accounts or stores, right? But highly, highly recommend that you have a process in place to look at this particular situation. There's the other side of this where if you're not getting pricing restored at all, you might not have your damages are more of missed opportunity than overpayment. And that is something that can also be considered for an ADR process of submission as well. So your state, for example, and this is what I think is going to happen. This is what I think is going to happen. If I had to do a guess, is a lot of these contract pharmacy access bills, like we saw just South Dakota, I think was the most recent one that went into effect. But these contract pharmacy access bills, as the year progresses, are going to go into effect. And then entities are going to have to figure out, well, which manufacturers are going to follow the state law and provide access to pricing on the day of the state law's effect. So if the state law goes into effect, and by the way, this is going to be my next webinar topic next month, so I'm kind of giving you a little bit a heads up, but still come to that one because this is going to be a good topic. But how do entities handle a process where the 340B ceiling price was not provided on the effective date of the contract pharmacy access law? And I will have more information for you on that next month. So I can't give you all the answers on this webinar. You got to come back the next month. So anyways, this is why I think this is a big topic, is that there is a possibility that the ADR process becomes a big deal as we follow this. Anyways, I like to keep it short. I don't like to waste anyone's time. And my goal is to provide value here, is that you're learning something new, that you as a 340B professional are on here. Maybe you're new to the 340B program. Maybe you're a veteran. My goal is that you join these webinars and spend 30 minutes, 45 minutes. Sometimes we go into an hour because of a lot of Q&A, but that you leave out of here saying, man, I learned something new and that was valuable. That's my goal. And I hope that I have achieved that today. The day that I stop doing that and stop providing value, then I think I'm going to have to consider not doing these anymore. But for right now, I hope that that is something that a value that I'm providing to you. So if you want to get in touch with us, you can follow us here. You get in touch here at the info at thefarmforce.com. You go to our website, call our number. We just released a new podcast episode on the New York Times Apexis article that you can find on Spotify. That was a really interesting discussion, just where we went through sort of facts and speculations of what the New York Times, this article that was posted about Apexis and its role in the 340B program. So you're welcome to check that out as well. And that is all I have to say today. I do want to allow for some Q&A. So if anyone has any questions, please feel free to post them. If you want to come on and unmute yourself and chat with me about anything related to this process, I would love to do that as well. I'm here. I'm here for that. If there are no questions, then we are good as well. So I'll wait to see. I'll give it another few seconds to see. I don't see any questions posted at this moment. And I'm checking to see if anyone has their hands raised. I don't see anyone. All right, cool. Well, I guess we'll keep it short today. Thank you so much for joining us on this webinar. Really appreciate it. We will be in touch, and I will see you next month. Thank you.